Hey guys, welcome back to my channel. Okay, so we were doing about the appointment of judges in Supreme Court and High Court in the previous lecture. That all we have done. Now we come on to current practice in the appointment of judges. That means in the previous lecture we have done that how judges can be appointed by consultation of president or by the governor of the state. If it's of the High Court or district, judges have to be appointed. Now that was all about what is mentioned in the constitution. Now what is scenario at the present that will be done in this topic. Despite a clear constitutional mandate, appointment of judges in practice remains a complex process. There has been extensive debate over the appointment procedure of judges, which has seen alterations in actual practice. Means there has been changes despite of at present appointment of Supreme Court and High Court follows a collegium model. Means there is a group of senior most judges of the Supreme Court or High Court, and that collegium only suggests that which person or which another judge of the court is eligible to be further promoted. Okay, means which person or which advocate or which court or which judge of this court has to be transferred to another court, right? So transfer ho chahe appointment of advocate as a judge ho, that all is done by the collegium. Collegium is a group of senior most judges of that court, which is a judicial creation through case laws, even though not constitutionally mandated. कॉन्स्टिट्यूशन में कोलेजियम मॉडल नहीं था. जब कॉन्स्टिट्यूशन बना तो ये मॉडल नहीं दिया गया था, लेकिन एज टाइम पास्ड, एज द नीड वाज फेल्ड थ्रू वेरियस केसेस दैट केम फॉरवर्ड, द वर्डिक्ट वाज गिवन according to which the appointment of Supreme Court and High Court judges changed. After collegium model for appointment of judges of Supreme Court, Chief Justice of India consults 4 senior most judges of Supreme Court. Means Chief Justice की तो consultation लेनी ही है. And apart from that, Chief Justice of India further consults 4 senior most judges of the Supreme Court, and that is the collegium of 5 judges. One is CJI and the rest 4 are the senior most judges of Supreme Court. There is an homework for you. You will find out and comment down below that who are the 5 judges in the collegium model at present. Okay. The Chief Justice of India sends his recommendations to Union Minister of Law and Justice, who then puts up the same to Prime Minister. Okay, so CJI sends his recommendations or sends the recommendation of the collegium to the Union Minister of Law, and from there it gets transferred to the Prime Minister. Prime Minister then transfers it or advises to the President. For High Courts, collegium comprises of Chief Justice of that High Court and 2 senior most judges. So half that of what happens in the Supreme Court. Supreme Court has 5, High Court has 3 judges in the collegium. One is obviously the Chief Justice and the rest 2 are senior most of the High Court. Chief Justice conveys his recommendation to the Chief Minister of the state and Governor of state, who in turn send their views directly to Union Minister of Law and Justice. So what happens for the collegium in High Court? The appointment preference or the appointment suggestion is given to the Chief Minister and Governor of the state, and from there it is transferred to the Union Minister of Law and Justice. Okay, complete material is then forwarded to CJI, who in consultation with the collegium of 2 judges of Supreme Court would send his recommendation to the Union Minister of Law and Justice. Means जो High Court ने recommendation दी उसको एक cross check किया जाता है by the collegium of Supreme Court, wherein there are 3 judges included. One is CJI and other 2 of the Supreme Court itself. And then after that, whatever is the consultation or whatever is the recommendation of the Supreme Court regarding that person जिसकी advice High Court से आई थी, तो उसको रिव्यू करता है सुप्रीम कोर्ट और बाद में अपना एडवाइस भेजता है यूनियन मिनिस्टर ऑफ लॉ को. ठीक है. Union Minister of Law then puts up the same to the Prime Minister, and then Prime Minister will give it to the President. The seniority of a judge plays a vital role in his or her elevation or appointment as Chief Justice. जितना सीनियर जज होगा उतने ही उनके चांसेस होंगे कि वो चीफ जस्टिस बने या उनका अपॉइंटमेंट या कह दो प्रमोशन हो. ठीक है. For initial appointment as a judge in High Court, for those from the lower judiciary, inter se seniority does matter, and for elevation of advocates from the bar, relative merit matters. seniors. Means inter-se seniority means amongst themselves, whoever is the senior, that will be promoted or he will be appointed as a judge. From lower judiciary means सब डिस्ट्रिक्ट लेवल पे जो जुडिशरी होती है, उनके जो जजेस हैं उनमें से सबसे ज़्यादा जो सीनियर होगा वो अपॉइंट हो जाएंगे एज अ जज ऑफ हाई कोर्ट, वो प्रमोट हो जाएंगे एज अ जज ऑफ हाई कोर्ट. एंड फॉर एलिवेशन ऑफ एडवोकेट्स फ्रॉम डायरेक्टली द बार काउंसिल ऑफ इंडिया, मेरिट मैटर्स. कितना कैसी एजुकेशन ली है, कहाँ से एजुकेशन ली है, सो दैट ऑल मैटर्स. Collegium model considers relative merits of those judges in the zone of consideration for elevation with reference to their judgments and cases. Tracing the historical debate on issue of appointment of judges. Right now we have done that what is at present. Now we will trace the history. Issue of appointment has been often linked to independence of judiciary, and there has been a constant tussle. Tussle means war of a sort of war, conflict between executive and judiciary over the appointment of judges. As early as 14th Law Commission report under chairmanship of MC Stalwart, India's first Attorney General in 1958, these concerns were raised. So what were the concerns? In the 14th Law Commission report, which was under the chairmanship of MC Stalwart, who was India's first Attorney General, there at that point there was since time being there is a tussle between executive and judiciary that how the judges would be appointed. Judiciary says that we only would appoint our staff, executive says that no, we should appoint it. So there has been a tussle, and it was also at the time of MC Stalwart. So he put forward, or he considered these things, and so there were some recommendations on the basis of these concerns which he gave. The commission noted the appointment or rejection of appointment of judges by executive in contrary to what judiciary suggested, creating rather awkward situations. Means commission had noted that जो appointment या appointment ना करना judges का by executive is opposite to what judiciary has said, and so there was another tussle. The report highlighted that several appointments were being made on political, regional, communal or other grounds, as a result of which the fittest of the lot were never appointed. That means if it was in the hands of the executive to appoint the judges, then they would favor those who would favoring them. Means a judge who was favoring a particular government, then that government will give the consultation or will appoint that particular judge only. So this was a bias which was going on, a partiality which was prevalent, in which the judge was appointed on political regional basis rather than of his educational qualifications or of his merits. So the best candidates or the fittest of the lot were lag behind. The commission thus suggested on strengthening process of consultation between executive and judiciary. So committee said that Committee Law Commission report 14th said that it is important that now there would be a link between executive and judiciary, and both on consultation will appoint the judges. Not a single organ, but both the organs will appoint. Later, a series of 3 judicial decisions, popularly known as 3 judges case, helped in development of modern collegiate system. So please remember this collegium system, which is present in current scenario, that has come from the 3 judges case. This development has been a result of a tumultuous process, but in modern practice, the first judge's case gave primacy to executive and stated that CJI's recommendation to president can be refused for cogent reasons. The first judge case was, it said it gave the supreme power to executive and said that if the CJI is recommending somebody to be appointed, then that recommendation may be refused by the president for some valid reason. It gave vast powers to executive for next 12 years in making judicial appointments. So after first judge's case, 12 years span of time, executive had vast powers to appoint the judges. This, however, was modified in second judge's case, Judgment held that Chief Justice of India has primacy in the matter of appointments to Supreme Court and High Courts, and that an appointment has to be in conformity with the final opinion of CJI, while emphasizing the desirability of consultation of CJ with other judges. That means in second judge's case of 1993, first judge's case was of 1981, second judge's case was of 1993. In that particular case, it was held, the verdict was that CJI would have the supreme power to appoint the Supreme Court or High Court judges, and the final appointment would be done on the consultation of Chief Justice with other judges. Means other judges would also be consulted, and of course final decision would be of CJI. Executive element in appointment process was reduced to minimum and political influence eliminated. Now after second judge's case, पॉलिटिकल इन्फ्लुएंस वॉज एलिमिनेटेड, उसको हटा दिया गया था. फर्स्ट जजेस केस में 12 साल तक पॉलिटिकल पावर ही दी गई थी, लेकिन सेकेंड जजेस केस में उसको हटा दिया गया था. दिस डिसीजन रेंडर्ड बाय अ 9 जज बेंच. और सेकेंड जजेस केस में कितने जजेस की बेंच थी? 9. Was however supported by only 5 judges, and other 4 did not concur with the majority opinion. Means the verdict came by the ratio of 5:4, wherein total number of judges were 9 and 5 were agreed upon on the same sense and 4 were agreed upon the other same sense, which was against the majority. Majority said that the political influence should be eliminated, but these 4 judges said that no, it should not be eliminated, and majority verdict is only considered as the final verdict, right? As we say, majority wins. So the same case. The years that followed witnessed some confusion in the process of appointment, as CJI made some unilateral appointment, and the role of president was reduced to a mere approval. That means only and only the decision was taken by CJI. There was no consultation with other judges, and president को फाइल तभी दी जाती थी when it was just to sign. ठीक है, प्रेसिडेंट को बस इतना बोला जाता था कि हमने सब कुछ कर दिया, अब बस इसमें साइन कर दो और काम ख़त्म करो. So president was just for a removal, for just signing that appointment letter, nothing else. Later in 1998, Supreme Court in a presidential reference emphasized upon the role of consultation and held that process of appointment of judges to Supreme Court and High Courts is an integrated participatory consultative process. So in 1998, it was held that appointment of judges should not be done unilaterally by only one person, but it should be done by consulting with the other judges, and it should be a participative process. Participatory होना चाहिए और consultative होना चाहिए, wherein the other judges would also consult the CJI that who should be appointed. CJI forms up his opinion after consultation with the plurality of judges. His opinion is formed by a body of senior judges, and that body of senior judges is only known as collegium at present. Okay, as stated before, collegium system is not constitutionally mandated, and thus legality of such a system invokes certain spectisms. Now the concerns or the spectisms we will do in the next lecture. This is all for this video. Thank you so much.